And the Senate did put in the request, and a second conference committee was appointed on House Bill 2062. But we understand that's in process on the House side, and a second conference committee has not yet been appointed.
Oh, probably first thing in the morning. Yep.
Okay. So that's not conference in conference right now.
No, not yet.
Okay.
Could I ask?
Well, we can open
question?
a House bill or a Senate
Yeah.
bill. Yes.
Okay, I just want to ask a question or two. Did you concur with anything that's on this list that we could kind of mark off our list? And people would know.
We did with Senate Bill 241. I don't know if Senate Bill 241 was in conference. I don't think it was. But I have some suggestions for some concurs.
Okay.
Did the House concur on anything that was in
We
the
haven't,
committee?
but we would be interested in chatting about that.
Sure. I'm looking at House Bill 2242, authorizing the governor to accept requests of concurrent jurisdiction from the federal government in certain circumstances. And the Senate amendment was to change the effective date from the statute book to the register. Yep. So that could be a
Absolutely.
House concur.
Yeah, I think that seems like that would be a good idea.
And same with 2371, amending the Kansas Revised Limited Liability Company Act. And the Senate amendment was to change the effective date from the statute book to the Kansas Register.
Yeah, that sounds good. My only question is that it is a large bill. And would it be better if we had it effective July 1st, just to give people a little more time, since the Limited Liability Act is quite lengthy? That would be my only question about that. Would it be better than doing it at the?
Would that be your?
Yeah, I'm making an, yes,
then?
I'll offer to House Bill 2371 to go back to having it effective July 1st.
Just a moment. Yes, the Senate will accept the House's offer.
Okay, that's great. So another one off the list. So we did make an offer, and the Senate accepted House Bill 2371 to go back to the effective date, back to the original House version.
Yes,
so if you could.
Thank you, Madam Chair. And that one will require a conference committee report. So we'll draft that for you and you'll run it on both sides.
And on 2242, you're going to make a motion on the floor to concur.
Yes, we will.
So that also leaves the possibility of 2347, changing the culpability required for certain types of theft and increasing the criminal penalty for theft. And the Senate amendment was to make theft of a motor vehicle with a value between $500 and $1,500 a level 10 non-person felony. And the thought there was for those Kansans who have a vehicle in that value range between $500 and $1,500, it impacts their life greatly if that is stolen, and you don't necessarily have the ability to go get a replacement vehicle. And so to discourage that theft, it was the thought of the Senate to make it a non-person felony if the value of the car is between $500 and $1,500. And that passed the Senate 39-0. Is that something the House could concur on?
Let me chat with my folks. Just 1 second.
did. So oftentimes, as you know, the conference committees, we put together our crime, punishment, and criminal procedure bills. So possibly now would be a good time to discuss what that looks like. And I'll just start the conversation with, since we were last on 2347, and that is a crime, punishment, and criminal procedure bill regarding theft of certain types of theft of vehicles. We also have, for possibly putting into that, would be Senate Bill 186 concerning prior convictions. Well, we need to amend that first. Hold on a second. Senate Bill 156, unlawful use of a laser pointer. 156, the contents thereof into 2347, and the contents of Senate Bill 84, criminal use of a financial card, gift cards, and put that into House Bill 2347.
Okay, so just so I understand, you would put Senate Bill 84 and Senate Bill 156 into House Bill 2347. And at the moment, we're not dealing with Senate Bill 186.
Correct.
Okay. So we do believe those are three crimes that are all separate and could be put together. And would like to counteroffer adding Senate Bill 71 and with those other three crimes. Yep.
Thank you, Madam Chair. One clarification. When we're talking about 2347, we're accepting the bill as it came out of the Senate.
Yes, the one about the theft of autos between 500 and 1,500. Yep. We're okay with that.
Okay, the Senate would accept that offer.
I would like to just make a comment about that 71 never came above the line in the House, even though so our body hasn't actually heard it. It's not in conference, but I do think that the three of us and others, and even the majority of our caucus, agree that Senate Bill 71 is very important. And we would like to have it included. And, I've talked to others about it and they feel the same way. But I'm just making just a little note that we are agreeing to something that the House has not passed across their floor.
So noted, thanks.
Okay.
Did the House have hearings on Senate Bill 71?
The committee?
Yeah.
Yes, we did.
Okay.
Mhm.
Thank you. So the Senate has, regarding Senate Bill 157, if we could open that for a minute. And that is regarding, if we'll have the reviser give a brief summary. One 57.
Thank you.
157.
Okay. Did we decide on the others or this is all part of it?
I said we were good with putting the contents of
okay,
Senate Bill 84, the contents of Senate Bill 156, and the contents of Senate Bill 71 into House Bill 2347.
Okay, great.
If the revisers are
Okay.
clear on that.
Advisors clear on that one? Okay, great. Okay, now you're moving to the next thing. Great.
Yes, Senate Bill 157, if we could get a brief from the reviser real quickly.
All right, thank you, Madam Chair. So Senate Bill 157, as it left the Senate, was just one section requiring the court to make copies of warrants available to compensated sureties, directing forfeiture to be set aside in deportation circumstances, and a 95% remittance provision. The House added the contents of Senate Bill 138 without any changes. That is the one that requires the statement of facts for probable cause justifying a search warrant to be made by a law enforcement officer, not by any person. And also added as Section 3 the contents of Senate Bill 244, again with no changes. That is the one that prohibits a compensated surety from making a loan for certain portions of the minimum appearance bond premium that's required. And then in the one section that was in the original Senate bill, the House made several amendments. First, the court making a copy available to the compensated surety is upon request. There is no time limit on either party there. The deportation provision was modified to apply only when there is showing that the defendant was not on an immigration detainer when the bond was posted, and the surety proves the defendant was deported prior to judgment of default. And And then the 95% remittance provision was changed to a 3-tier remittance, 90% within 90 days, 75% from 91 to 180 days, and then 50% if the defendant was returned within 181 to 70 days. I think that covers everything. So quite a few changes on the House side.
Thank you for that. Any questions for the reviser? Not seeing any, then, like you said, quite a few changes made by the House to the bill, which so considering where Senate Bill 157 is now with the House changes, we do have some further discussion on Senate Bill 157, and I'll turn that over then to Senator Titus.
So we'd like to take a look at possibly some changes to a warrant statute. There's been some due to some recent legislation, there's been some changes to warrants and public right of way, and we kind of dealt with something similar a couple of years ago or last year with wildlife and park law enforcement agents, just sort of making it clear about use of cameras in public right of ways. And we thought this would be an appropriate place to put in some similar requirements.
So I think we just have a question or two about it. So if you can remind us, we did a conference committee report yesterday about cameras on poles. And so it was a concur utilities bill on the floor, and yeah, not here, on the floor. And so can you explain, Reviser or Senator Titus, what this does with that bill that we passed?
So thank you. The intent here is, there's the bill that you concurred to removed any liability from the utility company. So it creates a scenario where it's still public right of way, but in most utility companies' case, it's still their private property. And so we've taken care of that liability piece, but now that there's no reason for a utility ever to say no, we wanted to put some parameters in place for when that private property gets used, so there's not undue government influence on that utility to allow access. And so I think this meets it's modeled after the Wildlife and Parks thing. That was a similar situation. We think this is some safe parameters to still allow law enforcement to operate the way they need, but it doesn't open up unfettered monitoring and searches with undue influence on private property. It doesn't impact public property and public right of way. Still completely fair game for whatever. So this is fairly narrow.
And was this discussed at all in Commerce or at the committee that we had, that utilities? Was there any discussion about this at all?
Not this, there was a robust discussion about scope, but not the specific part we thought. Based on our floor conversation, the part about searches and the constitutional pieces really weren't vetted appropriately, and it needed so judiciary to look at these pieces.
Representative Williams.
Does this language model what they did back with KDWP and the warrantless searches? The same language?
Madam Chair, it's not identical, but it's pretty similar. I can read you kind of what that one does. I would say the biggest difference between the two is that the Wildlife and Park statute makes some exceptions for searches that are authorized by the Constitution, by the Fourth Amendment. So there's a specific provision that allows that type of surveillance for exigent circumstances, consent searches under the Plain View Doctrine. Those are recognized exceptions to the Fourth Amendment, and so those are expressly in the Wildlife and Parks provision. There's also a provision to allow for surveillance in situations where they're trying to find a missing person. But other than those two exceptions, they're pretty similar.
Okay, I think we are, we are inclined yes on this, but I do feel like we need just a little bit of time to, because this is all new and we haven't seen this language till right now. So if we could have a little bit of time, but keep it, we're leaning yes, but if we could maybe move on to something else for the moment, and then, maybe get
Sure,
back to you on
appreciate
it.
that.
Mhm. Yeah.
I think we're all unanimous in support of it on this side, so
Okay.
if that helps.
I could go ahead and bring up something else if you might be amenable to that. I would like to put an offer on the table to put the language of House Bill 2349, which is not in conference, but we're calling it the scrap metal bill, but it's way minimized. And we will hear the language in just a minute, into House Bill 2155. Supervisors seem to think that fits okay there. And I'd like to explain more. I think House Bill 2155, it's in conference. It's saying that sheriffs have liability for official acts. If you remember, we added the word official before, and it was an old statute that needed some updating and that kind of thing. House Bill 2349, if I could give you just a little bit of background on that. It started out really with two parts, and it was, it has to do with the fact that the Attorney General's office is, they're tasked with investigating and enforcing the Scrap Metal Act now. And some of the bigger cities have found that some of the enforcement and even the investigation is really hard for the Attorney General to get around to the whole state and do that. And that was one part of it. So they're asking if they could have some enforcement, or excuse me, investigative powers. And then the other part of the bill, as it was introduced, was a scrap metal bill in the Scrap Metal Act, made it took it into the criminal realm rather than the civil realm. And that was the piece that seemed people to be very uneasy about. So we took that out. And so what we ended up with, that the House passed out, and I'd be interested in it was 122 to 1 or something along those lines. And then maybe, Jason, if you could just, or whoever, Jason, read the language that we ended up with in the scrap metal bill, because it really is just about 3 or 4 lines. So if you could, if you wouldn't mind doing that, if y'all would be okay with that. Yeah, you could read along. Yep, thank you.
Sure. Thank you, Madam Chair. And just to knock the vote out of the way there, it was 120 to 3.
120 to 3. Thank you.
Have that up as well. So the amendment, and if you have it up, it's easy to follow. It's KSA 50-6,109A. It's in the Scrap Metal Theft Reduction Act. Right now, the current law just says the Attorney General has jurisdiction and authority over all matters involving the act. So to the exclusion of law enforcement, obviously. So the language added is, except as provided in paragraph 2, the Attorney General has jurisdiction and authority. And the new paragraph 2 says, Kansas law enforcement officers are hereby authorized to conduct investigations of violations of the Scrap Metal Theft Reduction Act. Upon conclusion of an investigation, investigative reports shall be submitted to the Attorney General, regardless of whether any local action was taken as a result of such investigation.
So it's giving, and the reason is because at the moment, local law enforcement can't step onto scrap metal dealers' property to investigate the Scrap Metal Act. But this would give them the ability to investigate. They're still not doing the enforcement, but it gives them, they feel like they need a little bit more help in being able to investigate what's going on, because it's just not, they need to be more active doing it, because they haven't been able to have it investigated and have it enforced. At the moment, they have to wait for an Attorney General, deputy, or I don't know what they're called, assistant attorney general, whatever, to come to the town to be able to step onto the scrap metal dealer property. And so this would give local law enforcement the ability to do more investigations. And as you can see, it was quite, it was very, it passed the House 120 to 3.
Thank you for that. And were there opponents on the bill?
There were opponents at the beginning. And then it was really one of those bills that the puzzle pieces all came together. And at the end, there were, Attorney General was not an opponent. The scrap metal dealers and lobbyists were not opponents. They were, in fact, very much in favor.
Well, this is a bill that the Senate did not hear in committee, so it's new information to us. So we'll have to confer on that for just a moment. appreciate the work of the House on getting proponents and opponents together on 2349. I know that's always a contentious issue when we're talking about scrap metal, it seems. So appreciate the work of our House colleagues on that. And it's not a bill that the Senate committee had a hearing on, so it's kind of new to us for this session and what the issues are. So, if we would be willing to accept the House offer on 2349 into 2155, if the House would accept the offer of the Senate on Senate Bill 157, since we're kind of all already there anyway on 157, that would be the Senate position on those.
Okay, and that's fair. That sounds good. I mean, no doubt this new section on 157 is longer than the scrap metal bill that we're proposing. Oh, and I did have one thing I said wrong before. There weren't any opponents even from the beginning of the scrap metal bill, but there were neutrals. And then as we worked on it, everyone was a proponent. So there were not any opponents. But we're going to have to come back to that tomorrow, I think. We don't feel like we can accept that one at this moment. So let's just pause on both of those, I guess, offers. And we can hopefully come to resolution tomorrow on that.
Sure, right. One of the bills, scrap metal is giving law enforcement more opportunity to do things, and the warrants is kind of well, let's make sure that we have parameters in place too. So it's kind of a balance between both sides of those issues in a couple of different bills. So thank you for that. Or I guess it's Senate sub for Senate Bill 54 or House sub? Senate sub for 54? Senate sub for Senate Bill 54. Yeah, Senator Titus has a question.
Thank you, Madam Chair. So when we had done this in the various versions the last 2 years, I had been a proponent of the Judicial Council study that you guys removed. In order to keep that out, I've asked Chair Warren and would ask same of you, would you be willing to submit just a request to the Judicial Council that they study the topic rather than have it in statute? If you guys would jointly submit that, I wouldn't have any objection to moving forward.
So you're saying concur if we agreed to that?
Words in the chair's mouth, but
Yeah.
that's the idea, yeah.
Yeah, I think I'm happy that we took them out of it, actually, because I think it was burdensome and it was a little unclear to them exactly what they would need to do. But to ask if they would take it on as one of their topics that they would study, I would be very happy to do that. So, yeah, I think are you saying the two chairs? Okay.
Sure. So then the Senate's going to concur on substitute for Senate Bill 54, and that's something we can do on our floor.
Okay, moving on to possibly another idea. I would put on the table an offer to have the language in Senate Bill 53, which is not in conference. It has to do with county law libraries. Just putting that language into Senate Bill 204, which is in conference. And I would love to get a read from the revisers, Senate Bill 53, what happened with 53?
Madam Chair, that was, let me find the date that it happened exactly. It was stricken from the calendar by Rule 1507.
Okay, so it was passed out of the Senate Judiciary Committee, but then stayed below the line and then stricken.
The Senate passed it out across their floor.
Oh, I see.
You guys passed it out of committee.
Oh, it was
but
stricken
it was
from our
below the
calendar,
line.
below our line. Okay, yeah.
So that sounds kind of, maybe it should be an offer from our side.
I agree, it does.
Well, let's take a look at that in a minute.
Okay.
That also leaves Senate Bill 135 regarding providing precedents of child-related orders issued under the Protection from Abuse Act. There were some House technical changes to it that the Senate non-concurred in.
Briefing on what happened with that? What the changes were? Senate Bill 135. Oh, you already did. Oh, that was the one that it was a technical change.
Yeah, Madam Chair, it was just a technical change. You added the number 1 on page 2, line 26. That was it. Just an error in numbering that we missed.
So, okay, well, go ahead.
We don't really have an offer on Senate Bill 135. I mean, we can always concur on our side, but
Yeah, so what we did with it was there was a technical error and we needed to add the number 1. So we did. And then there was a thought, just to go back, that there was another PFA, Protection from Abuse bill, that we had in the House. And we were thinking maybe in conference they could go together. I think you ended up concurring to that one and it went to the governor. And so this change was just, again, technical, and it was a PFA, kind of 2 separate bills, one that was introduced in the House, one in the Senate. You concurred on the one, and then we made a change on the Senate bill side. Or you didn't make it? Yeah, you didn't make any
we
changes.
don't have any
Yeah.
offer or anything on that one. We can always.
So would you be
concur.
willing to concur on 135?
I mean, we don't need to agree to do that
No,
here. We
that's
can
true.
just do that
Okay.
at any time. But
Okay.
so I'd say we visit 186. If we could just get a brief from the reviser.
All right. Thank you again, Madam Chair. So the Senate version of the bill requires affidavits or sworn testimony in support of probable cause requirements to be made available to law enforcement agencies prior to execution of a warrant or summons. The House retained that provision, so you'll notice Section 2 of the bill is the same as Section 1 of the original bill. 2 things were added, or 2 other bills were added, both House bills. The first is prior convictions of a crime that are determined unconstitutional are not used in your criminal history score. That's current law. And the addition of an exception is that if the basis of that determination is later overruled or reversed, you would be able to count those crimes in your criminal history again under the The other bill that was added deals with defendants charged with certain sex offenses. When setting their appearance bond and their conditions of release, the magistrate is required to do a few things, including look at prior convictions and offenses upon available evidence. If they find that the defendant has a prior conviction of a sexually violent crime, there's a minimum bond of $750,000, cash or surety, minimum conditions of no contact with victims or witnesses, and mandatory house arrest program. And then there are restrictions on reduction or modification of the bond unless there's a determination that the defendant is not a public safety risk or a flight risk.
So thank you for that, Mr. Thompson. And so Senate Bill 186, you said, contains the contents of House Bill 2401 and House Bill 2389. And I don't think, so House Bill 2401 wasn't even in the Senate at all, so it didn't get a hearing in committee or anything. And 2389, same thing for 2389. So these are two bills that the Senate Judiciary Committee didn't have a hearing on. Yeah, go ahead, Senator.
Clarify. Clarify, you didn't pass either of those two bills out of Judiciary Committee, or they came out in this, or what was just the procedure?
Madam Chair, they came
Yeah.
out as a part of this bill. You didn't send them out separately.
We sent them out all together. And they did pass over the House, yep.
Right, it was passed out of the House 100 to 18. Is there an offer on Wayne 86? I guess I had brought that up, since it's a Senate bill, but the contents, like I said, there are two things the Senate didn't even have a hearing on, so we'd have to leave that open for, I guess, what our offer on that one is, so.
Yeah, okay, and I'm fine with that because I feel like we're a little bit up in the air again with 157, with the language about the polls. These all are involved with our crimes, punishment, and criminal procedures. And then I'm just going to mention two others. I'm not making an offer, but I'm just making it clear to people. We have two other bills that have to do with crimes, punishment, and criminal procedure. House Bill 2183, which is the element of the crime of sexual exploitation of a child. And that's the AI one. And so we have that one. And then we also have one that we did pass across the House floor. You did not. It's the jailhouse witness testimony. So I feel like there's some things in play with our crimes, punishment, criminal procedure bills that maybe we just need to take a pause tonight on those and be aware of it. And then we kind of need to talk to some of our leadership about some of the offer that you gave us about 157. And I think you wanted to hold on a different one. So if that's okay, if we come back to crimes, punishment, criminal procedure tomorrow. Because you may have something, we may have a new one come up tomorrow too.
Well, there aren't going to be any more added to conference committee. Is there anything pending other than 2062 coming back?
Well, I think we're going to have the sub for Household 2228. I don't know where that one.
Right, if that passes out of the Senate tomorrow.
Right, yeah.
Yeah. That is true. And then another that's in conference. We had talked about a couple that are in conference, but not necessarily in the that if we wanted to start taking a look at 21, Senate sub for 2164.
Yep, we can talk about that one. Since it's a House bill, I'll go ahead and start with that one if
Right,
we
so I
want to go
guess
there.
If you want to pull it up, not me, but sure,
Okay.
go ahead.
No, we're all good. So Senate sub for House Bill 2164, it's called a House bill here, of course. It was a different Senate bill when you heard it, and then you put it in a House shell. And when we heard it, it was 2401 in the House. And we heard it in, I'm sorry, 2404. Was it 04? Yeah, okay, excuse me, 2404. We heard it right just towards the end, and it did not go, it went below the line, then it was stricken. So we've not passed it across the floor of the House. So that's where we are with that one. I think you're aware that in committee, we did put several amendments on that I can mention those amendments. We're still interested in those amendments, and you all can talk about it if you'd like, or anything else that, if we want to go ahead with that.
Sure, if you want to go ahead. We appreciate that it got out of the House committee, and likewise ours got out. So the bill started the same in both chambers, both in the Senate and the House. And in the Senate, it remained clean as it was introduced, with one definition change about non-public schools. And so the definition of non-public school was amended a little bit to clarify regarding homeschool and microschool situations for non-public schools. Otherwise, the heart of the bill stayed as introduced, both when it came out of Senate Judiciary Committee and across the Senate floor. And it has a good, strong Senate bipartisan support. The vote in the Senate was 38-2. And so understanding, though, that the House didn't take it up on the House floor. So, I mean, the Senate position is the Senate position, but if you have some offer to make,
Yep. Okay, yeah.
if the House has some offer to make.
We do have an offer to make, and it would be that we amend Senate sub for House Bill 2164 with 4 different amendments. And I think the revisor could read them because they were 4 amendments that we did put on in the House committee, but I can talk you through them too. And then if you want more details about what they are exactly, then we could have the revisor do that. One amendment we put on in our committee was, it had to do with if a school is a polling place or a place of worship, then the person on the sex offender registry list could go ahead, go to their voting, or go to the church. What I'd like to offer is that we don't talk about the polling place at all. It's just the place of worship that they would go. If their church is meeting on school property, they would be able to go to church and be in community, which I think is very important for this population. And then our amendment said they would go and leave whenever the event is over. That's one amendment. The second one has to do with the sentencing grid. And in committee, we took the we moved the first offense, the first time it happens, from a severity level 6 to a severity level 8. Because on the first offense, if it's a 6, it's presumptive prison, and it's generally 36 months for the first offense. And one thing that was determinative for me was that Missouri has the same sort of law and about sex offenders. And in the Missouri code, it's a misdemeanor. So I felt like I should say, because the committee voted on this, felt like that a severity level 6 for the first offense was just too much, 36 months presumptive prison. And so we asked to move it down to a level 8, which is presumptive probation, 18 months. And the committee passed that out of our committee as another amendment. The third amendment had to do with if a person is a student and they're on the list, because the bill says that anyone who's 18 years of age or older, this is who it applies to. So if a person is a student at the school and then they turn 18, like maybe during their senior year, then they are able to finish their schooling. And we put that on. And then the last one that we put on was, just want to make sure I say this correctly. If the victim, right now the bill says if the victim is under age 18, it applies. And we changed that to if the victim is under age 16. So those were the 4 amendments that we would like to offer for Senate Sub for House Bill 2164.
I should back up for a second. If we could have the reviser explain the bill, first of all.
Sure. Thank you, Madam Chair. 2164 would make it unlawful for any sex offender who's 18 years of age or older, whose underlying offense for which they're required to register was a crime against a victim who is less than 18 years of age, to enter onto school property or attend a school activity. Both of those terms are defined. On a first conviction, it would be a severity level 6 prison felony, like you guys just talked about. On a second one, it would be a severity level 5. And then on a third or subsequent, it would be a severity level 3. And then we amended the citation of the act to add this new section into the act. And then we amended the definition section to define school property, school activity, and then the non-public school amendment that Senator Warren referenced.
Thank you. So the bill, as it left the Senate, applies to sex offenders on the registry who are 18 years of older and their crime was a sex crime against a minor.
Yes, Madam Chair, that's accurate.
Okay, and it's restricting them from entering school property or attending school activities, right?
Yes.
Okay, and my understanding is that this bill came about because there was an incident at an elementary school in Kansas that the principal had allowed a person over 18 on the sex offender registry for a sex crime committed against a minor to attend an elementary school dance. And parents were upset and concerned and shocked to learn that there weren't any Kansas restrictions in place you had to be on the registry, but there were no restrictions about where you could go or what you could do, and including you could attend elementary school dances. Through testimony, that's how the bill came to be, and is the bill as it was heard in the Senate, supported by district attorneys from Johnson County, Sedgwick County, Shawnee County. The KNEA supported it. The Kansas Association of School Boards, except for one minor tweak, was neutral on the bill. The school superintendent where this happened was a proponent of the bill, and numerous parents involved came and testified. So like I said, it came out from the committee and from the Senate in the current form that it is, understanding that the committee worked on it, but the House as a whole wasn't above the line, so the House as a whole hasn't heard this. So there was an attempted amendment on the Senate floor, but it was rejected, and then the passage of the bill was 38-2. So great bipartisan support on an issue, I think, of importance to everyone. And I think everyone agrees with the underlying premise of the bill. It's just kind of, well, what's the final bill going to look like? So with that, these are 4 proposed amendments to a bill that is in the position that it is. So we'd like to take into consideration, do you have these in a written balloon format that we could study?
Jason, what would you, I mean, we have them, they were separate in our committee, but I don't know if you were able to put them together for this yet.
And separate is fine too, just something we
Okay.
could look at as we're
Uh-huh.
probably going to consider these till we meet again.
Okay, okay, yeah.
Yeah, so
Jason?
Madam Chair, the amendments I would have would be on the House version of the bill, not the version that passed the Senate as a substitute for a House bill. And then if you pulled the House version, they'd be mixed in with a bunch of other amendments that you're not offering. So I can do a new one that has either all 4 or all 4 of them separate. At least 2
I
of
think
them
we're
are,
fine right now with just the conceptual
at least 2 of them are
amendments.
just changing one number. And I can even tell you what line that number changes in. The other 2 a little bit longer, but 2 of them are just simple number changes.
And I think if our side is okay with just the concept right now, that's fine for us to consider that
Okay.
while we're considering a couple of other things. So with that, have we covered all the bills that are in conference?
I do have one other thing I'd like to bring, I would like to mention. I'd like to ask the revisers if I'm calculating right, and I don't know if we've officially done this, so maybe we can't, but I think we have a shell, Senate Bill 237. And is that like an official shell? I mean, can we use it at this point, or do we have to wait till things happen?
So, Madam Chair, the concept of shell is very much not official.
Okay.
Your tentative agreement was to move that into House Bill 2062.
Yeah.
So
Mhm.
until you kind of have that agreement,
Okay.
everything is tentative, but you do tentatively have plans for those contents, and you could use it at any time that you're ready.
Okay. And would that also be true of Senate Bill 84 and Senate Bill 156, the 2 crime bills that we put into House Bill 2347?
84 and 156,
Mhm.
yes. You have
Okay.
tentative agreements.
Okay, so since we do have those, I'm going to bring something up. You may need to sleep on this one also, but we passed House Bill 2323, and it has to do with the insurance commissioner being able to establish procedures for civil action instead of criminal action. And so that's not in conference because it passed the House. What was, do you know the 122-1? And so I would like to put that in Senate Bill 237, which is a shell. So put House Bill 2323 into Senate Bill 237.
Well,
So,
we'll take that under advisement that that's not something we're able to agree to now.
Sure.
So, but we'll
Yeah.
think about it overnight.
okay, that makes sense. Just wanted to get that out there. Do you all have anything else for tonight? We have several things each side needs to contemplate.
So if we're looking at potential uses of potential shells, there are a couple of Senate bills to be taking a look at. One would be Senate Bill 222, which passed the Senate 31-9, and I think did not get out of House Judiciary Committee,
It was tabled in our committee, actually.
right? So prohibiting deference to a state agency's interpretation of a statute, rule, or regulation or document. And another one would be House Bill 128, mandatory reporting obligations for licensed social workers when working under the supervision of an attorney. And that passed out of the Senate 40-0. So just some
Okay.
couple
Yeah,
things to think about.
Good to think about. Well, okay, and I'll also bring up House Bill 2212, which I'm laughing at because I was the only proponent. Has to do with the claims against the state, and it's also not in conference. So we've got that one hanging out there too, but it's not a super urgent bill, but it would be nice for when we start meeting this fall, our claims against the state committee, if we have that done, but not urgent. But if we happen to have an extra shell sitting around, we can think about it.
Certainly, and certainly need to talk with leadership and shells and things like that. So,
Okay.
okay, so a couple of things to consider overnight, a couple of conference committee reports to prepare and get signed, and then the assignment of a second conference committee for 2062.
Yes. Yeah, we'll get,
Right,
yeah.
okay. And you guys are back on the floor at 10, and so are we.
Do y'all have conference committees in the morning before 10?
No.
Possibly meet at 9? Thank you for coming. I'm wondering if anyone knows if tax conference committee is still meeting, or
Is that 7:30 a.m. or 7:30 p.m.?
either late night or early morning.
So tax is meeting at 7:10 tonight.
Oh, no.
Ways and Means, sorry. Tax is not scheduled. Okay, so you're off.
So what if we tentatively say here at 9 o'clock tomorrow morning?
We have to caucus at 9:30.
I mean, I live a block away, so 8:30 is fine with me. I know about quite a few, everybody else commutes. You're staying, okay.
I can be here.
So should we say 8:30? 8:30 tomorrow morning?
Yep.
Okay.
Okay, 8:30, and Natalie can help get the room.
Okay, thank you. Okay, thank you, everybody.
Then with that, the meeting is adjourned.
Yep, thank you, adjourned.